the case of Gomez versus State of South Dakota, Steven Jensen, Jerry Miller, et al. They are accused of malicious prosecution and accessory to kidnapping under color of law and deprivation of rights under color of law. Kidnapping. Right here on this transcript, Jerry Miller, what page was that? Anyways, he's saying he didn't see anything illegal. You can certainly challenge the underlying conviction. So I've already made incriminating statements which were obtained under the fruit of the poisonous tree doctrine, which is inadmissible. So Jerry Miller speaking on this part. Mr. Miller, Your Honor, whatever, through a modified work release program. He made false and misleading statements. He misled the courts, and the court was involved, so they knew it. So there's a meeting of the minds there. When the courts accepted this false statement, knowing that it was false, because the judge entered this. And they were separating felonies from the same case, which caused me more injuries. So and then he didn't even know how to do his sentencing. They messed up on the sentencing, and then he said there was nothing wrong with it. But then after this, they issued an amended sentencing, a second amended sentencing, and then a third amended sentence nunc pro tunc that I was telling them to correct. I was telling the lawyers about the issues, and then the lawyers relayed that, costing me extra money, like $1,200 for an attorney out of the 300 building. And he's also telling me in here that I can pursue whatever remedy I want. There's a witness to these proceedings. Okay. Now, he said the modified work release, right? Release reason, bonded out. Gets work release? No. So under the full faith and credit clause, the records, acts, and documents here get the full faith and credit. Release, bonded out. Now this guy, bond specifying methods and conditions of release, there ain't no modified work release, nothing. Must be drug crash, there's no work release. There's no work release. Nothing about work release. Anyways, this tells me I understand that if I violate any condition of my release, which I did, I said this because they were only doing this for Hispanics and Native Americans. All the white people that were coming up for bond reductions were getting their bonds reduced with no conditions. They were getting their bonds reinstated with no conditions. But the Mexican guy that went before me had to do this from Rapid City all the way to Elk Point every week. So when he said he couldn't do it because it was too far, they denied his bond reduction. That Steven Jensen was presiding over those hearings. There were several people in the courtroom that day that were coming up for bond reduction hearings. So when it was my turn, I noticed, I'm Mexican. I'm Native American. So I said, yeah, I would do it. And I did mislead the courts intentionally because my lawyer had already told me that I was arrested in violation of the 4th, 5th, and 14th Amendments. And the state dismissing that case with prejudice is proof of knowledge that they violated my 4th Amendment rights, my 5th Amendment rights, and my 14th Amendment rights. So see, it says, the terms and conditions of any further release will be determined. If I fail to appear before the court as required, an additional charge of failure to appear may be instituted against me, not second-degree escape. And by law, under South Dakota codified laws, they have to tell me. It should have said a charge of second-degree escape may be instituted against me. They did not do it. They're fabricating charges. They're fabricating warrants. Now, when he said, when we went back on that hearing, I filed this after that versus Melissa Larson. Name of defendant, Nicholas A. Davis. Additional defendants, Melissa Larson, Clerk of Courts, Deputy Palmer, North Sioux City Police. Maybe he might be Union County, I don't know. Union County Sheriff's Office. Jerry A. Miller, Prosecuting Attorney for Elk Point, Union County, State of Claim. On June 7, 2008, at approximately 1:40 a.m., I pulled into a Pronto gas station where officers had an individual pulled over. I parked a few spaces away so as to give them space. Before I could exit my vehicle, officers approached my vehicle and proceeded to investigate me without any probable cause. Deputy Palmer ran my name and found I had a fabricated warrant, a daytime warrant for an overdraft of $30. I'm seeking punitive damages for the violation of my 4th and 14th Amendment's rights relating to unreasonable searches and seizures, as well as unlawful and illegal execution of a daytime only arrest warrant executed at night. Now it comes out now that that warrant was fabricated. There was no warrant. Not only that, they maliciously prosecuted me and convicted me of escape. I never escaped. You guys seen the paper there. I bonded out. So, state of claim. Deputy Palmer then contacted Magistrate Larson, and she's not even a magistrate, so she was impersonating a court magistrate, a magistrate judge, where Clerk of Court Larson verbally changed the warrant to an anytime warrant, abusing her authority and powers and her office. Deputy Palmer advised Nicholas Davis of these facts, and Officer Davis placed me under arrest. I bonded out of jail on June 24, 2008. A condition of my bond was to appear at the sheriff's office, so that's incorrect. They misled me to believe that, but you see the documents proved me wrong. On a weekly basis to exchange a drug patch. I refused to do so because it was violating my 5th Amendment rights. Furthermore, my lawyer had told me that the arrest was illegal, so any fruits of the poisonous tree is inadmissible in any court of law. So the following week, I have a copy of the order, bond specifying methods and conditions of release, where it says, in the event I violate any condition or fail to appear after arrest, additional charge of failure to appear may be instituted against me if I fail to appear at court. But since I got arrested because the niece of Douglas Hoffman, the granddaughter of Douglas Hoffman, or his daughter, some relative of Douglas Hoffman, a judicial officer in the state of South Dakota, was involved in criminal gang activity and got involved in a shootout. I was driving through the area of the incident, and officers pulled a car I was a passenger in over and proceeded to investigate us. They brought Sidney Hoffman to the scene and had me in the back seat of a cruiser and shone a light on my face so I couldn't see past the flashlight. And I heard Sidney Hoffman being asked, "Is this the guy?" And she responded, "No, that's not him." So she identified to the officers that I was not the suspect involved in her little criminal gang activity shootout. And they shut the door on me and took me to jail anyways. And then they charged me with carrying a concealed weapon because I had a pocket knife on me in an area where shootouts were happening. Now, I was not involved. I did not know Sidney Hoffman. I never met Sidney Hoffman. I was never involved with Sidney Hoffman. But they arrested me and charged me with that and got me to plead guilty to the carrying a concealed weapon and tampering with records because I was crossing out things on their papers. Well, that was fruit of the poisonous tree as well because it was an unreasonable seizure. I was not the subject of their investigation. Furthermore, Nicholas Davis was investigating thefts in the area or around the Pronto gas station area. And he was just investigating every car that pulled up. Now, mind you, who in their right mind coming to rob a place would pull up next to an officer with his lights on to rob the place? It's not. Motion to amend or add to affidavit bringing facts to attention of the courts. This was filed in this case here as a result of that case of Jerry Miller. I'm going to go through these fast. I only got a few seconds. They miscalculated dates. This is the petition for habeas corpus. He said I could pursue remedies. I pursued all of these remedies almost simultaneously, back to back. But for the erroneous advice provided by trial counsel, petitioner would not have pled guilty to second-degree escape had he known the elements of his crime did not rise to that level. Motion for withdrawal of guilty plea. This was also filed in